This
Nation.
conference will now be recorded.
Oh, it's being recorded. Okay. So Naomi is from Listigoch Mi'kmaq First Nation in Gaspé-Gawagi. She holds a BA from Dalhousie, an LLB from Dalhousie, an LLL from Ottawa, LLM from Osgood, and is currently working on her PhD with the University of Alberta. As of June 2016, she is full-time faculty at the Schulich School of Law at Dalhousie University, and she holds the Chancellor's Chair in Aboriginal Law and Policy. As a legal scholar, she is most interested in writing about how the law can be harnessed to promote the well-being of Indigenous peoples in Canada and conveying this information in accessible ways. So without further ado, Naomi, thank you so much for being here. And I'll just let folks know if they have any questions along the way, you can throw them in the chat or feel free to turn off your mic, but we'll try to keep them short to keep things on track. So yeah, I'll take track of any questions that come in and we'll sort those out as they come. All right, thanks a lot, everyone. Enjoy.
Thanks. Thank you so much, Megan, for the invitation. I do appreciate it. Waldasi Begisin Giskuk, which means I'm very happy to be with you today. I also would like to thank those of you who submitted questions. They were super helpful in trying to structure the presentation, so I really appreciate that, and I have tried to reflect that in how I formed the presentation, but also super open to taking questions at any point as opposed to just waiting till the end. Go ahead and ask questions as we work our way through. I did send my PowerPoint presentation to Megan to share with you in advance if you wanted to take notes while we were going along. And I have my email at the end of the slide deck if you have further questions. And try to, in developing this, try to keep it sort of plain language, knowing that this is not a legal audience, but at the same time trying to cover the highlights, as well as giving resources. So I have lots of links embedded in the PowerPoint to assist you, and some of those I will be just showing you briefly as we go through. So I think that's it. So yes, I will now move to working through this PowerPoint with you guys. So the first question you might have is looking even at the title. When Megan sent it around, it was she used the title Indigenous Law, and these days we are using terminology like Indigenous a lot more than Aboriginal. So your first question might be, why did she use Aboriginal law as opposed to Indigenous law? So a bit of a long story, but the short answer is in the Constitution Act, there is recognition of Aboriginal and treaty rights. And we're going to talk about Aboriginal rights, and that informs the duty to consult. And our Constitution, 1982 actually refers to the Aboriginal peoples of Canada as including Indians, Métis, and Inuit. Yeah, and it uses that sort of outdated term Indians, which is still actually a concept using Canadian law because we have the Indian Act, which is another story, but I can entertain questions later if you want on that. We now use the term First Nations, but Aboriginal was a sort of a large sort of homogenizing term to refer to the descendants of the original peoples of Canada. But languages evolve, and it's currently evolving in this field. And because of things like the UN Declaration on the Rights of Indigenous Peoples, which I will talk about as part of this presentation, people are now using the term Indigenous peoples more often. So why wouldn't you refer to that to refer to the law? Well, so when we're referring to Aboriginal law, we're actually referring to the development of cases that have come out of those sections of the Constitution that I'm going to look at with you shortly. So we still kind of reserve this title of Aboriginal law for it. The concept of Indigenous law is also a concept, but it's distinct to a large extent from the concept of Aboriginal law. And we won't have a chance to get into that too much, but that actually is now being used in legal circles to refer to the laws of Indigenous people. So Mi'kmaq people's laws. And there's a sort of, well, not sort of, there is a sort of revitalization movement happening right now with Indigenous people trying to re-engage their laws using the resources they have available to them. Just as a matter of a little aside, some work we did this year with some students and a group of knowledge holders and elders was looking at the Mi'kmaq concept of Nadugalimk, which the Nova Scotia Sustainability Act also references as well. But it's a Mi'kmaq concept that has to do with land and resource, with resource use and this idea of stewardship, and not to use more of the land that you should. Anyway, so that's an example of a Mi'kmaq law or concept. That's not going to be the focus of my presentation, but if that is something in the future that you guys have an interest in, I can direct Megan to some resources on this to help you out. So that's why we use Aboriginal law as opposed to Indigenous law in this particular context, because Aboriginal law largely refers to Canadian law as it applies to Indigenous people. So that's what we're going to be looking at. So with that long spiel to start it off, let's get into the concept of Aboriginal law or Aboriginal rights. So what we are primarily referring to here is this concept of rights belonging to Indigenous peoples as a collective that pre-exist or existed before the arrival of Europeans. And it recognizes the fact that Indigenous peoples had rights and legal orders and organized societies before the arrival of Europeans, and that these rights were never extinguished, removed. There was no conquering of the Indigenous peoples here, so that these rights exist, continue to exist in the law. Now, in the US, this was recognized as early as 1820, but unfortunately in Canada, it took a little longer, even though we eventually relied on the US cases to advance our law. But the main case recognizing that Indigenous or Aboriginal rights exist as part of Canadian law came from a Supreme Court of Canada decision called Calder in 1973. And that led then to a push for when Canada came to repatriate its constitution in 1982, calls for the inclusion of a provision in the Constitution to give greater protection to these Aboriginal rights. Because the Supreme Court of Canada decision from 1973, Calder, recognized these rights as existing, but also suggested that the government had almost unilateral power to extinguish these rights or remove them. It said it has to be fairly clear that the government intended to extinguish these rights or get rid of them, but it gave the government essentially all the power in relation to these rights, nonetheless still recognizing their existence. But what happened in 1982 is that this part of the Constitution entrenches the language is, and here I'll just show you the clause so you can see if you all right, I'm just going to see if I can move this over, and you should now be seeing, I hope, another screen, which is the part of, so this is the Constitution Act 1982, and here there's a few provisions, subsections of it, but the main one is Section 35, which says the existing Aboriginal and treaty rights of the Aboriginal peoples are hereby recognized and affirmed. And so it wasn't creating Aboriginal rights because these already existed. They pre-existed Confederation and the arrival of Europeans, but recognizing them. Now, the idea was that, I'm going to go away from this now, the idea was that this was supposed to be further fleshed out because it's pretty broad, right? And vague, what does it actually mean in practice? This was supposed to be fleshed out in further constitutional conferences, and there were supposed to be amendments, but it's really hard for us in Canada to amend our constitution. So that never really, although there were efforts to, it never actually took shape. So what happened over the years is that the content of Section 35 has largely been set out through the interpretation of the courts, primarily the Supreme Court of Canada, our highest court. And over the last 30 some years or so, there's been about 35 plus decisions from the court giving us content to Section 35. Now, it's also possible for governments to recognize Section 35 through their policies, through agreements, and also through legislation. And we do and have seen some of that, but not a lot. In terms of recognition of Section 35 rights through legislation, we haven't seen a lot of that. Interestingly, more recently, the federal government has been a bit more active on this. Two examples include the Indigenous Languages Right Act that was passed in 2019 that said that Aboriginal languages are a Section 35 right protected by the Constitution. Similarly, there's a bill on Indigenous child welfare, and it recognizes the right to self-govern over child and family services as a right protected to Indigenous groups under Section 35. That's also incidentally being challenged by the government of Quebec. That's another story I can talk to you after if you want to learn more about that. But it's interesting. We are starting to now see governments play a little bit more of a more robust role in seeing their role in defining and elucidating what Aboriginal rights are. So yeah, and like I said at the beginning, this is sort of me just giving you some high-level takeaways of this area of law. I will say, though, too, in teaching you a little bit about the sort of the status quo or the current law, that I do think that we are on the cusp of significant change. I'm maybe being overly optimistic, but I do think that we will be seeing some change, and I'll speak to that. So despite it being progressive to the extent that it recognizes Aboriginal and treaty rights through Section 35 and the Supreme Court of Canada's decisions, both the Truth and Reconciliation Commission of Canada, as well as many legal scholars, myself included, have critiqued the current law as still being deeply colonial in its orientation, both in principle as well as in practice, how it gets implemented. And I could say a lot more about that, but I don't want to belabor that because you're just learning this stuff, but just keep in mind that there's still a lot of critique about how the current law operates. And we might see that as we unpack some more of these slides. Happy to address that as a further question after. One of the main things, and you see this at the bottom of my little slide deck, is because of the doctrine of discovery. A lot of Canadian law still operates on this idea that the Crown acquired ownership and control over the lands and the people in North America simply by arriving here and declaring it to be such. So, and that, as I said, is a matter in principle is problematic, as that doctrine of discovery has been, pretty well completely discredited as being very racist in its orientation, as well as impacting on how the Aboriginal rights tests and doctrine that comes out of the case law. I'll try to unpack that more so you get a bit more of a practical appreciation about that. So there's been critique, and one of the things that the Truth and Reconciliation Commission said in its 2015 report is that to get towards true reconciliation, there needs to be a dramatic reform of this area of law based in a nation-to-nation relationship as well as a treaty relationship, and that the UN Declaration, oh, that's one of my dogs, sorry about that. Megan is quite familiar with him. That reconciliation needs to be informed by the UN Declaration on the Rights of Indigenous Peoples, or what we call UNDRIP for short, or the Declaration. I have given you a hyperlink there, which is a link to the entire UN Declaration. It's an extensive document. It was 20 years in the making at the UN. It has, I think, something like 24 preamble provisions, as well as 46 articles, and many of those articles have subsections. But it's intended to be fairly comprehensive, addressing the rights of Indigenous peoples across the world, and it focuses both on collective rights and individual rights. And Indigenous peoples throughout the world participated in the drafting of this at the UN, and it was eventually supported by the UN. It is intended to be clear that the rights of Indigenous peoples are fundamental human rights law. I'm writing an article that will come out next week, and if some of you are interested, I can forward it to Megan and sort of trying to unpack some things about UNDRIP. But this UNDRIP already has implications for Canadian law, and this is a point that is often not well understood. As a lawyer, I actually argued a case where it was successfully argued that UNDRIP informed whether the government had an obligation to consult with First Nations with respect to social assistance policy on reserve. because the duty to consult framework that we're going to talk about doesn't often see social assistance as sort of falling into the picture of what's included to be consulted about. And I was successful in convincing a court that UNDRIP applied and that there ought to be a duty to consult in that particular context. So it already does apply, but Canada is introducing a bill which may become law perhaps as early as next week. It's at third reading at the Senate. That confirms that the UN Declaration applies as fundamental human rights law within Canada, which is already the case, but it will help convince those who think otherwise that this is clearly the case, and also commits Canada to timely implementation. Canada has to develop an implementation plan about how it's going to look at its law, develop new law to make sure that Canadian law is consistent with the UN Declaration. Now, Canada's focus is primarily on its own work, so the federal government's work, because a lot of what the provinces do as well impact and touch on Indigenous people, there also is a role for the provinces to play. Some provinces have been proactive in this regard. BC passed a law similar to Bill C-15 in 2019, committing itself to developing an action plan to make sure that its laws and approaches are consistent with the UN Declaration. There are a few other provinces that are actively looking at having similar legislation. I think Nova Scotia should be looking at that as well. It is something that I've raised with some of the people in government that I know. As far as I know, this doesn't seem to be very far on the radar, but I think that that will be something we will continue to push for. Anyway, if you want the hyperlink there to read more about the BC bill is there for your information. Okay, so my point with this slide is simply that particularly with the UN Declaration, we may be seeing some advancements in the law, sort of expanding, I think, where some of this law that I'm talking to you about today is going. So I've tried to incorporate it in my slides where UNDRIP might push things out a bit more. Okay. So the next question, and somebody asked the difference between Aboriginal rights and treaty rights, and that's great, and it sets us up for talking about the duty to consult as well. All of these sort of concepts been developed under Section 35. So in terms of the concept of Aboriginal rights, which are distinct from treaty rights, and I'll address those on my next slide, the Supreme Court has said that what Aboriginal rights are fall along a spectrum, and that spectrum has to do with connection to land. So at one end of the spectrum is what we call Aboriginal title, which is the right to traditional land. So Indigenous groups may have claims to large swaths of territories that they traditionally inhabited. And so the courts have said yes, and there was a Supreme Court of Canada case from 2014 from British Columbia called Chilcotin, where about 6,000 hectares of lands were found to be Aboriginal title lands belonging to the Chilcotin Nation. And the court has given us some insights about what does it mean when we declare Aboriginal title. And the court has said it gives almost use akin to fee simple ownership, that the Indigenous group, now on the one hand, they hold it collectively instead of individually, but the Indigenous group has the right to manage and control these lands. Now, there is a role for other governments as well, but they have to respect those rights at the same time. I can get more into sort of the nitty gritty of that interaction, but I'll leave that perhaps to the end. But so there's Aboriginal title as one form of Aboriginal right. And then we have other forms of Aboriginal rights. These are the ones that we might see or hear about in the media or in the courts a bit more, such as the right to hunt and fish or harvest wood or other natural resources. And so, and it has to be on territory that the group has a connection to, the courts have told us. And then as sort of at the other end of the spectrum, the court has also indicated that there are non-site specific Aboriginal rights. So where the importance of the right doesn't sort of hinge on the connection to land, and that might be something like language rights or self-government. there's a bit of feedback there. Somebody might have their mic on. So if you're able to maybe turn that off. Okay, anyway, I will continue. Thank you. So all of these rights have to be proven in accordance with a test set out by the Supreme Court of Canada. And there's a different test for title. For title, the Indigenous group has to show exclusive use and occupation of a territory prior to the assertion of Crown sovereignty. And then with these other rights, the court has said that these other rights have to be shown that these are part of custom, practices, or traditions integral to the group pre-contact. I could say a lot more about those tests and critiques of them, but that is currently the requirement. Indigenous groups are required to prove these tests in order to show that they have an Aboriginal right in the courts. Okay. So just to sort of counterpoint while we're talking about land, because often this is where when talking about Indigenous rights, a lot of the focus is, just to sort of point to what UNDRIP says about Indigenous people's rights to land. A primary article is Article 26, which says that Indigenous people have the right to lands, territories, and resources which they have traditionally owned, occupied. So this seems to be consistent with what the Supreme Court has said Aboriginal title is, but the UNDRIP also goes on to say, or otherwise used and acquired, which is interesting because the Supreme Court of Canada title test doesn't necessarily acknowledge situations where an Indigenous group may be in the 1800s or 19th century, moved somewhere after being in one place and have been living there for 200 years. On the Supreme Court of Canada test, that doesn't cut it. So there's the unfortunate example of Mi'kmaq people in Newfoundland, and it is contested whether Mi'kmaq were always in Newfoundland or traveled and sort of started living there post-contact. And there was a case, and the court held, based on the evidence that was produced, although it is contentious, that they accepted the view that Mi'kmaq moved there after contact or after Crown assertion of sovereignty. And so unfortunately, the poor Mi'kmaq of Newfoundland were out of luck when it came to trying to prove title in Newfoundland. Although if we move to a sort of UNDRIP sort of model, it also recognizes the right of Indigenous people to other parcels of land otherwise acquired. And it further goes on to say that Indigenous people have the right to own, use, develop, and control land and territories and resources that they possess, either by reason of traditional ownership or traditional occupation or use, as well as those which they have otherwise acquired. So that just kind of speaks to their, ways to use the land. And it also calls on states, so governments, to give legal recognition and protection to those lands and resources. Yes, and that there has to be due recognition to custom and traditions. And I think I cut off the word systems, but there you go. So that's just to give you a little sense of how the law might be changing or moving to be more consistent with UNDRIP as we potentially go in that direction. Let's now talk about treaty rights. This could be a long conversation as well. So again, just giving the highlights. There are different types of treaties. When I teach, I sort of put them in three categories. There's a few more, but the three most relevant for talking about Section 35 are the peace and friendship treaties, which are the treaties that apply here. Land cession treaties, those would be treaties that we see in Ontario and westward into the prairies, and what are called modern treaties, and we often see these sort of in BC and also in the north. So my first point is that, these different types of treaties contain different clauses. There are some similarities across them, but with both the land cession and modern treaties, there are provisions in them respecting that seem to suggest that Indigenous people ceded, gave up, surrendered their interest in huge swaths of land. Now, this is contentious as well. The courts have seen these treaties in this way. Many Indigenous people, especially in the prairies in Ontario, say that was not the deal, that was not intended. The treaty was written not in a language that we spoke. That was not what the negotiators told us. but there's this whole issue around whether these treaties were actually, the indigenous groups actually intended to give up, their interest or their claim to significant parcels of land in exchange in some of these treaties for potentially much, much smaller reserve land, as well as some rights to hunt and fish and perhaps to some annuities. That's a bigger issue. There's a couple of good articles I can send if people are interested. Maybe just send Megan a note and she can keep a little list of who's interested in receiving what, and I can provide that. But when it comes to here, what we have are peace and friendship treaties that were signed primarily in the 17th century. And they do not include any provisions with respect to land cession. So somebody had asked the question, what does unceded territory mean? So unceded territory is a reference to that we had never signed treaties that include any type of land cession, right? So that also means that the Mi'kmaq people still have claim to Aboriginal title. Right, so we go back to the previous slide where we talked about, what the different types of Aboriginal rights. So the argument is that those who signed treaties that gave up or surrender lands are no longer able to argue for in court recognition of their Aboriginal title to their traditional lands. But in Nova Scotia, we never signed away, or you could be argued to have signed away a right to claim traditional territory. And I have here a link, and I think it's from the University of Cape Breton, but they have some of the text of the treaty and some discussion. There are several different peace and friendship treaties, but primarily what these were about were, this was after Britain had effectively conquered France in their claim or battle to say that they had some control over North America. And many of the indigenous people in this part of the country had sided initially or had good relations with the French. And once this war was over, there was still a concern that the indigenous groups would sort of not be very keen on the British. So the British wanted to enter treaties with the Mi'kmaq and other indigenous groups here in order to secure friendship, peace, neutrality, as well as setting sort of the terms for how to sort of coexist here in this territory. And so there are specific provisions in these treaties. Some of them refer to things like the Mi'kmaq shall be able to hunt and fish as usual. A famous clause that is in a couple of the treaties refers to a truck house, which was what the Supreme Court of Canada looked at in the Marshall decision as being a right to not only hunt and fish, but to also trade these goods with settlers. So the right to a moderate livelihood. Yeah, so when it comes to treaties, I guess sort of my final point here is that there's different types of orientations to what treaties are, and we're not really settled yet in Canada on that. There's a school of thought that, and some earlier cases that sort of suggest that, it's about the Crown granting rights to the indigenous people, right? So giving them the right to be able to hunt and fish, or giving them the ability to have a moderate livelihood. Whereas another perspective would say, well, no, Mi'kmaq already had these inherent rights, but these agreements were about also the Crown's obligations. So there's just a debate about, who was granting what to whom. And so just to sort of challenge you in seeing treaties as like being simply about the Crown giving certain rights to Native folks. There's another perspective to it. And I guess the other perspective is also that, indigenous people tend to see the treaties as setting the basis for a long-term relationship. And even in these treaties that were quite short and not, sort of written at high principle, that these still give us the basis and the grounds as an ongoing relationship. And in that regard, many indigenous people say, with respect to the more historical treaties, that we can't just look at the four corners of the treaty, that we have to look at the intentions of both parties, what they were saying together in the negotiations, the context at the time. And that's sort of contrary to or opposed to another school of thought and some older cases that tend to see these as sort of one-time transactions, especially with the land cession treaties, like one-time big land transaction deals. But Indigenous people, the Truth and Reconciliation Commission, the Royal Commission on Aboriginal Peoples have all very much pointed towards the other approach, is seeing treaties as the basis for a long-term relationship and should be the basis of a future going forward. As far as where we are with the courts right now, the courts have said that you don't just look at the written terms of the treaty, and that was emphasized in the Marshall decision as well, that you do look to the surrounding discussions and the intentions of the party that they may have expressed, and the overall sort of social context at the time. So that's just a little introduction to treaties and some of the sort of nuances or complexities that are trying to understand them. Okay, so now that we have gone through those two things, we can jump into what is the duty to consult. So this concept, it existed before 2004. It was discussed in some cases about in terms of what is good, appropriate government conduct when it might be potentially trying to argue that it justifiably infringes Aboriginal or treaty rights. That was in the context of proven rights, but this case called Haida comes along in 2004. It's from British Columbia, and says that we need to sort of open up this concept of the duty to consult to encapsulate rights that have yet to be proven, that are asserted by the Indigenous group, but not yet proven. And, you know, to add a little bit to that, there's lots of things happening in Canada. There are Indigenous groups going to court to prove rights, but going to court is extremely expensive. You know, hundreds of thousands, if not $1 million. Like, I think the Chilcotin case where the group proved Aboriginal title, I believe cost somewhere in the vicinity of 10 million just for the Indigenous side. So these things are expensive. And so there is a disincentive there to go to court to seek proving of rights. The court also really encourages groups to be negotiating and at negotiation tables. And you might know something about this, but there are negotiation tables between Indigenous peoples, the province, and the federal government, a lot of them sort of trilateral tables where conversations about rights and recognition of rights are happening. This is happening in Nova Scotia. It's been happening for well over, I think, 15 years now, and I'll talk a little bit more about that later in the presentation. So people are trying to work to negotiate longer term agreements to address the longer term relationship. So recognizing that this is all kind of happening, the court in Haida said we can't just say that the government only has a duty to consult when its decisions might impact on Aboriginal rights when the right is proven, because it takes forever to prove them. So we need to protect rights that are credibly asserted, that we think exist or could possibly exist, but have not been proven through some process like negotiations or the courts. So yeah, so that's some of the language that I've brought here from the case. You know, the court put an emphasis on the treaty relationship. So the treaty served to reconcile pre-existing Aboriginal sovereignty with assumed Crown sovereignty and to define the rights guaranteed by Section 35. Yeah, so this promise is realized and sovereignty claims reconcile through the process of honorable negotiations. Yeah, but the process of negotiation in modern treaties can take many years. And so in the meantime, the court said the Crown acting honorably, so this is an idea that we expect the Crown to act honorably in its dealings with Indigenous peoples, cannot cavalierly run roughshod over Aboriginal rights where claims affecting these interests are being seriously pursued in the process of treaty negotiations and proof. It must respect these potential but yet unproven interests. So that this sort of idea of protecting yet unproven Aboriginal rights is really at the heart of the duty to consult. Now, it also applies to proven rights, but yeah, so remember that it applies to both. So let's look at when is there a duty? So the court has said it's kind of these two things. So when the Crown has knowledge, real or constructive, of the potential existence of an Aboriginal right or title and contemplates conduct that might adversely affect it. That is effectively the test for when there would be a duty. So there's a lot more I can pack, but I'll stick to these little points that I have here. So starting with the real or constructive knowledge, that would be when the government might, will know that, a group has claims. They might be at a negotiation table with them, which was the case in Haida. And also the court has said whenever there's a treaty, the government certainly has notice of a treaty. So the Crown has knowledge. Either it should know or does know of the existence of potential claims of Aboriginal rights or title. Again, this can be proven or unproven rights. And so to boil this down a little bit more, often the emphasis, and I think with planners, this would obviously be a lot on issues relating to lands. So, I haven't spoken yet much about reserve lands, but certainly if there was a decision that might have an impact on reserve lands, or even lands that may have once been reserve lands, but for some historical colonial reason, Indigenous people lost control over those lands, those might be affected. So those of you in HRM will know that like Tufts Cove or Turtle Cove is like an area, what we call a kind of specific claims land, where it used to be reserve land, and there was this land became lost to the Mi'kmaq, but they have now regained it, and there's negotiation. So there are some lands like this in the province, and there's also various reserve lands. This link I'll show you briefly. Hopefully it comes up pretty quickly. This is helpful. This is produced by Canada, the Department of Indigenous Services, but it shows all known and recognized reserve lands, and you can sort of zone in. And anyway, you'll see the various reserve lands. You can see it where it shows various parcels. There are, 13 Mi'kmaq communities in Nova Scotia, but beyond them having some of them have 2 or 3 or more parcels of reserve land, not just the main reserve that the community lives on. Another nice little feature of this, if you're looking for information about communities, is head up to this little thing here that says First Nations profile. If you click on this, First Nations, you will see a map, and you can choose Nova Scotia. It gives you all 13 communities, their address. I'm going to choose Acadia. And there's all kinds of information here. It can tell you who the chief and council are. If you hit governance, it'll show you who are the current chief and council. And it will also show you the reserves that they claim to. So Acadia has 6 parcels of reserve. So you get some information about that. Anyway, that's a resource, another resource for you to have to give you a sense of some of the reserve land in Nova Scotia. So obviously there could be issues, and the courts have definitely indicated that there would be a duty to consult with respect to interest in reserve land, even though that's not technically regarded as an Aboriginal rights or title land, but certainly reserve land. As well, claims to Aboriginal title would be included. Now, Mi'kmaq are at a negotiation table and have been for well over a decade or so, and they have claimed title to all of Nova Scotia in general. However, I would probably add to that as well that despite making that claim, it's not their intent that they would gain title necessarily to all of Nova Scotia and then exclude all the other people who currently live here. These tables not only sort of discuss Aboriginal title, but compensation and restitution. Restitution is often looked at with respect to, getting replacement lands that would be with respect to Crown lands. So these are the kinds of things that are being discussed. So with respect to thinking about those negotiations, I would see it as not thinking about it as like negotiations where you've got like a private landholder so much as another government with interest over lands. But we can talk a little bit more about that later. Then, you speaking to the other types of Aboriginal rights that we talked about, the site-specific rights, there would be lands that, and they would probably overlap with title lands, but where there are also claims to Aboriginal rights to hunt or to fish or to harvest. So these are all potential claims that could trigger a duty to consult. What about other rights? So rights to language, rights to education, rights to health or socioeconomic development. So far, under the Supreme Court of Canada case law, there hasn't been a ton of recognition with respect to those types of rights. Yet, when you read things like the UN Declaration, within that there are all kinds of articles that touch on these rights. Remember, I said it was fairly comprehensive. I've linked here. This is a summary I've created of UNDRIP for my students in just a page or two, but that you can search for it. Let's just put in language, for example. But the UN Declaration is a little longer than this, but I just tried to provide a summary. But for example, if you were to put in language, you'd see that, Article 14, for example, talks about the right of Indigenous peoples to establish control over their education systems in their own languages. So my point here is that the UN Declaration has a bunch of provisions that go beyond certainly just interest in land and with respect to a variety of other interests, which we may be moving towards greater recognition of. Remember at the beginning, I referenced that I had a case back in 2013 where I was successfully able to argue that the government should consult with Mi'kmaq with regard to changes in social assistance policy on reserve. So I think this is where we are sort of moving, sort of a broader conception of what are the things that Mi'kmaq people have a right to be consulted over. Okay, next, the second piece of this is and contemplates conduct that might adversely affect it. So, so what kind of conduct? Clearly, so one thing I might say first is that the courts have held that it's the government that has this obligation, not private parties. And so, but that most of the things that private parties do are often, overlaid by government regulation. So government licensing and authorizations, if they're going to approve an activity, a private activity that might have an impact on Aboriginal and treaty rights, will trigger the duty. There was questions about, sort of from you guys, is there a duty to consult with respect to sort of more planning strategies, higher level stuff, right? Housing, poverty, parklands, culture plans. So at the first answer to this is that the courts have said even beyond just sort of immediate licensing that affect a right, there can also higher level strategic decisions, which can ultimately lead to later decisions down the road that will impact on a right, can trigger the duty. So, for example, in the Haida case itself, what was at issue there was the approval of a transfer of a license to cut a tree farm license, which would eventually, a couple of steps later, lead to some cutting of trees that were of significance to the Haida. And even though it wasn't the license itself to cut, the court said, well, eventually that transfer is going to lead to cutting. So these higher level decisions kind of get caught up too, because eventually down the line, they will have an impact on they could have an impact on an Aboriginal right. So with respect to the question about planning strategies, certainly I think that could get caught in higher level. And then the other part of this question was about, things like housing, poverty. That kind of goes back to my earlier discussion that a lot of the focus has been on activities on land, but there may be, and especially if we're trying to conform more with the UN Declaration, issues around poverty or even housing, do attract and are seen as part of, Aboriginal people's human rights. So if you were respecting that, you might take a broader view to what you should consult over. Okay. Now, another question I had is, okay, so what about municipalities? Do municipalities have their own duty? So there was a bunch of case law for a bit that kind of questioned that. And for a little while, it seemed that no, it's the province who consults for the municipality. But that case law has sort of been pushed aside, and more recent case law from the Supreme Court of Canada, a decision called Clyde from 2017, which was about an administrative tribunal's duty to consult. So it wasn't directly about a municipality, but it held that essentially any body that is exercising the functions of government and have been delegated decision-making authority does have a duty with respect to those decisions. So, you know, municipalities as a form of delegated government would have the duty to consult with respect to matters under its jurisdiction. And there's a couple of articles I have on that I can certainly share with Megan to pass on if people are interested in that. Let me see about this one. What about creating policy for reviewing processing applications for private development, such as new buildings or subdivision on private lands? So I would say yes, because going back to Aboriginal, what Aboriginal title is, the court has not yet ruled out that Aboriginal title could not include claims over what is now fee simple lands. It's a contentious point, and I think at negotiation tables, the way that the parties are trying to address it, recognizing that, you know, no one's going to get sent away from where they currently live, but that there needs to be compensation. There's still an Aboriginal interest, but, you know, it may not be restitution of those lands, which is the answer, but potentially compensation and restitution of other lands. But nonetheless, there is, with respect to lands that are privately owned, there may still be Aboriginal title claims to it. There may also be claims to lesser rights, like if it's a huge swath of private property that no one has any, you know, development on yet, there may be, you know, harvesting activities that nonetheless happen on those lands. So I would say that the answer would be yes. Okay, next question. What does the duty require? So the court, never being as clear as you might want, doesn't give us real direct answers. It says, well, it depends. It depends on a couple of things: the strength of the claim and the extent of the adverse impact. So they say it sort of falls along a spectrum from strong to weak. And often the government side and the Indigenous side rarely agree on where things fall. So, you know, there's lots of, I think, in between from time to time. So the court has said a strong case that will require, so you see this little box, as the court said, okay, at a lower end, there's less duties, at a higher end, there's more duties. But a strong case will be one where the right asserted, or we're dealing with the case of a proven right, a right that's already proven in court. I don't know, moderate livelihood fisheries, for example, could be one, or other sustenance rights. If there's a strong claim for them, or if they have been proven, that will put them at the higher level, as well as if what's being proposed is going to have significant impacts on the exercise of those rights, that's on the strong side. And then if it's more tenuous, or if the impacts are more speculative, you might be at the lower end. At the lower end, the courts have said consultation means giving notice about the decision, giving information, disclosure, and being responsive to questions that come. Now, the court has also said that even at a low level, you can't already close your mind. You can't just be like, well, I'm just going to go through the motions and say, okay, here's the information, and we're going to do what we always intended to do anyway. So the court has said the consultation, even at the lowest level, cannot exclude the potential for accommodating Aboriginal concerns, right? So there's got to be an openness and willingness to do that. At the higher end of the spectrum, there's a lot more. There's potentially an opportunity to participate in the decision-making, an opportunity to voice concerns, an opportunity to receive reasons addressing the concerns raised and how those might be mitigated, potentially funding to participate in that process, being provided accessible, understandable information. So one recent case where the court talked about this was involving Inuit in Clyde River, and it was seismic testing, and the proponent went and just gave them a huge information dump, like thousands of pages about the project, all in English, not translated, all sent via email, and they have got big bandwidth problems up in Clyde River, and so most of them couldn't download it. And the court said that didn't cut it. That's not a meaningful provision of information. So it has to be accessible information and potentially accommodation of the Aboriginal folks concerned. So that might be taking mitigating measures. It could be compensation. That we have some guidance on this from the court, but you know, taking some steps to address the Indigenous concerns. On this, the court has said with respect to the duty to consult that it doesn't give Indigenous peoples a veto, but it did say that, however, consent can be required in some cases of established rights, but not in every case. So this is a little bit of a contentious area. It gets thrown a lot around. There's no Indigenous veto, but the court has been a little unclear about when those situations of consent might exist, even with established rights. So they haven't given us a lot of indication on that. And this might be an area with the UN Declaration that we might see change. And if you've been listening to any of the conversation or debate around the new bill on the UNDRIP, it's this concern, at least from business, perhaps, from where it is the language in the UNDRIP speaks about free, prior, and informed consent. In a couple of the articles, particularly ones in decisions relating to land, also decisions relating to implementing legislative or administrative measures that impact Indigenous people's rights. So it'll be interesting to see what's going to happen in the future on this. Some of the scholars who have written about it doesn't mean that we're going to go from a situation where effectively now we have a Crown veto, because the duty to consult is primarily a procedural right, and at the end of the day, the Crown can still make a decision, to one where it's an Indigenous veto, where the Indigenous group gets it. What many scholars are saying is that it will just be a different mindset. It will be a paradigm shift where we might not see it as being these competing vetoes, but more maybe a situation that looks more akin to something like co-management, where the parties respect each other and come up with processes where there is more of a give and take and joint decision making. We will see. Happy to share some articles on some of that if people are interested. But that's potentially where we may be going with respect to consultation if we are respecting the UN Declaration. Okay, I know I'm running out of time a little bit, but I'm getting towards the end. Just a few last slides. This is a big one. Who gets consulted, right? The case law, often we think in terms of First Nations or Indian Act bans, but the law has actually said that there are more rights holders than that. So often the cases have come as being issues about Indian Act ban councils, but if some of you were following what was happening in 2019 in BC involving the Wet'suwet'en, where you had the Indian Act chief and councils approving a pipeline, but yet members of the hereditary chiefs and the traditional governance saying that they did not accept that and they were against it. There's case law that suggests, well, this group can and has been acting with respect to making decisions, that traditional governments may also be rights holders, right? That the rights holders are not actually determined by the Indian Act. And so that's been one of the arguments, is that the Indian Act shouldn't dictate who makes the decisions, right? It's the rights holders are the actual collective who have the rights, and it's who speaks on behalf of the collective, which is complex. Right, so the UN Declaration says that Indigenous people have the right to participate in decision making through representatives chosen by themselves in accordance with their own procedures. But it does lead to a complex issue, and colonialism has a lot to do with it, where you might have competing views, right? So you might have Indian Act ban councils, you could have potentially traditional governments stepping forward. There are also groups of people like non-status First Nations people. And in Nova Scotia, for example, that would be the Native Council of Nova Scotia. We have had no time to get into this, but there's a long history in Canada of people not being recognized as being Indians under the law for a whole set of problematic and discriminatory reasons, which still has an impact on today. I can come back and just do a whole speech on that one, or a whole presentation. But that has led to groups of folks who have collectively come together to represent their interest as sort of Indigenous peoples who are not recognized as having status under the law. And it gets further complicated. Somebody might ask me, what about Métis in Nova Scotia? And that opens up a whole other can of worms. So thus far, the position of Mi'kmaq in the province is that there are no real Métis. There was a declaration signed by the Mi'kmaq a couple years ago with the Métis National Council. Case law to date in the Maritimes suggests that there wasn't sort of a historical Métis community, but rather that, you know, if you were of mixed heritage, you either conform with one group or another. You either joined with the Mi'kmaq or blended more into mainstream society. It's a complex area. I'm not suggesting to give answers on this one, but so there are these claims of other groups out there. And then you have situations where you have collections of bands deciding to act together in their interests. So we have this in Nova Scotia. We have the Assembly of Nova Scotia Mi'kmaq Chiefs. So what do you do with this complex picture? It's tough. So this comes from a textbook, and I gave it to my students in my class. You know, ideally, we would hope that the Indigenous groups can sort of figure out some of this stuff internally on their own and present whom they want to be consulted on their behalf themselves and present a unified position. You know, colonialism and lateral violence and those sorts of things doesn't, you know, in a perfect world, that would be great. It doesn't always happen. In Nova Scotia, we've got a lot we can work with, and I'll get to that in a second. But a good practice is for the Crown to accept the Aboriginal group's position on who the rights holder is, unless there is reason to doubt it or if facing conflicting demands for consultation. And then, you know, when it comes to Indian Act bands or First Nations, the Crown should also be open to consulting with representatives potentially other than Chief and Council. So that's just some advice, because the case law is held that all of these potential groups potentially are owed a duty to consult. So it makes it complex. Now, to make life a little bit easier, in Nova Scotia, there's been sort of, at least for a lot of groups, a coming together. Now it gets a little complicated, but you probably have heard that in Nova Scotia we have the Made in Nova Scotia process. Then that's actually a reference to the sort of negotiations, the ongoing tripartite negotiations. But over the years, the Mi'kmaq have formed a fairly sophisticated governance system where the 13 communities work together. Now, it has happened that at times certain communities get frustrated with the other chiefs or whatever, and so at various times people have left and come back. For the most part, it tries to represent a unified front. At the moment, two bands are sort of out, not participating in this, which is Sipekne'katik and I think Member 2. But you know, this is a group that I think it's a good place to start if you're contemplating consultation issues. So essentially, the 13 Mi'kmaq chiefs, or at the moment 11, plus 2 ex officio members of the Grand Council. So the traditional form of Mi'kmaq governance has a seat. So, you know, so they're already participating in that. So you can be assured that you know, the Grand Council actually have a voice already in the way that the Mi'kmaq have decided to structure their governance. So the Grand Chief and the Grand Captain are part of this, and then it's sort of, you know, it's not sort of, it is a government, and there are various sort of aspects to this. So there is a sort of the Mi'kmaq bureaucracy is called Gwilmugma Gusuahan, but KMKNO for short, or the Mi'kmaq Rights Office. But this is an office that provides support to the Assembly of Nova Scotia Mi'kmaq Chiefs. There's the Tripartite Forum, which is a body that negotiates not on clear Aboriginal and title and rights issues or treaty rights, but other issues that affect Mi'kmaq, and representatives from both levels of government sit there. So there's a group on cultural and heritage, economic rights, economic development, education, health, justice, social, sports, and recreation. So there's tables going on this. There's also the formal negotiation table on Aboriginal titles, self-government, treaty rights. There's also a consultation office, and I want to say a little bit more about that. so the main takeaways here is that the Mi'kmaq in Nova Scotia are quite organized, and this organization is a great one to start with in terms of if you're thinking about consultation, right? So they actually have this terms of reference, and you can access it there, but they have already given thought to how they want to be consulted. So the terms of reference provide that if somebody wants to consult, they don't go to an individual band. They start with the consultation office. And they have a director of consultation, Twyla Gadet. I have linked her information on a future slide here. But basically, you go there, and they actually sort out between the individual First Nations who might be most affected, whether they decide whether they want this organization to be consulted on their behalf, or the communities have a decision. They can decide if they want to go on it on their own. So it's a great place to start. So somebody earlier asked about, like, what about consultation fatigue, which is a real thing, but we've already had some sort of planning on the Mi'kmaq side in Nova Scotia that you sort of start at this level, and then internally they decide in consultation with the groups that are most affected who wants to be consulted and how. So that's excellent. There's also a number of other documents on consultation that are available on the province's Office of Aboriginal Affairs. It's got the terms of reference. It's also got policy guidelines on consultation, information for proponents, and some other stuff. So just to show you that. Megan, I see it's 1:02. How do you want to proceed? I've got just a couple more slides left that I can just introduce and then let your folks go.
Yeah, I say we just keep going, and if anyone has to go ahead, and for those of you who can stay, that would be great.
Okay, cool. All right, and it's just a couple more slides. So yeah, I just wanted to provide that information and then get to some broader engagement questions that folks had. So one of them was like, how do you avoid engagement fatigue, overwhelming, or adding to busy workloads? Well, I think at least in Nova Scotia, the answer is kind of easy with respect to the 13 First Nations, or the 11 who are currently in, which is, and if you start with the Mi'kmaq Rights Office, they will tell you if somebody is not in and who you should contact. But if you start there, that's a great way in, and then you get to know this process. So that will help. And the whole idea of setting up this office was to avoid the situation where, individual communities are being hammered day in and day out with consultation requests, because it's absolutely correct that there is sort of a fatigue that happens. So here's the link to Twyla Gadet, the director of consultation for KMKNO. So connecting with them, and here's my other point, not just when there's consultation, but there was a question about, what are good practices. I think being proactive, if you've never sort of established that relationship before, reaching out before there's a thing to consult over, but just to say, hi, here we are, here's what we do. We contemplate that there might be these things in the future, perhaps, that we might involve with consulting. What would be the best way to engage with you and how? I think that would make a lot of sense. Now, there's these other groups, right? So KMKNO, it's got representatives of the 13 Indian Act or First Nations groups, plus the traditional government, the Grand Council. But there are other groups that have interests, as I've suggested. Probably one of the clearer ones is representing the off-reserve status and non-status groups in the Native Council of Nova Scotia. They don't take the view that they are represented by the KMK, the Rights Initiative, and have been found to be owed a duty to consult in some cases. And they represent off-reserve, urban, or primarily rural, I would say, people who identify as Mi'kmaq. They have various districts. I think they also represent some urban as well. On the urban side, then we also have the Mi'kmaq Friendship Center. So what I've tried to do on this slide is just give you the who else is around that you might want to engage with on particular issues. So we've got the Atlantic Policy Congress of First Nations Chiefs that are involved in some matters, but I probably would start with KMKNO. They sort of represent this on some issues, similar things as the Mi'kmaq Rights Office. But on some issues, with respect to the off-reserve non-status, one might want to reach out to the Native Council. There's also the Native Women's Association of Nova Scotia, and then the Friendship Center. So I can't go into too much detail about them, but what I would say is that it would never hurt to reach out proactively if you're thinking about that you might have a later consultation, to again develop sort of a plan, or start by building a relationship and then a potential plan for what to do when consultation might occur in the future, because they will have a sort of sense of what their community members might need. They might actually have a policy on that. So proactive reaching out with some of these groups, I think, would be wise. And also, you know, the Nova Scotia Office of Aboriginal Affairs is supposed to be there to support its departments, and I think it's delegated government. So that's another place of support. Here's another question: how to highlight focus material for public engagement, how to strengthen bonds and connections. You know, and I think the question the longer question I had was simply, how do you, you know, you know, sometimes just sending out the questionnaire or other things, you can say that you've done these, you checked off your engagement box, but it doesn't actually result in, you know, either people coming out to meetings or really engaging with the process. So thinking of that, my couple pieces of advice is, of course, it depends on the topic, but you might maybe partner with an organization who works with the communities in order to think through what would be effective ways of engaging. These organizations tend to know their communities quite well, and I'll show you a couple more slides with different organizations, but they might help you be able to sort of tweak your message to make it seem relevant to First Nations or the particular Indigenous groups you want to reach out to. Because oftentimes Indigenous people are dealing with a lot on their plates, as communities are, and sometimes if it's people living on reserve or even in an urban setting, they might be focused on very particular sort of issues and may not see necessarily the relevance of some bigger sort of planning processes, how that impacts on their day-to-day lives. But I think some of the organizations that they work with might be able to give you some of those ideas. And I sort of wonder too, and we've seen this in other contexts, ideas of navigators, sort of training someone up who works with an Indigenous organization to be able to almost help navigate or translate, maybe it's a translator, what it is, the sort of policy work that you're doing and how it relates to the day-to-day lives and can impact on people. So in this regard, I did already point out these organizations. These are some of the bigger ones: Native Council, Native Women, the Mi'kmaq Friendship Center. Then there are all kinds of other organizations serving Indigenous folks in Nova Scotia. You can go read up about it. We have an education board, the Mi'kmaq Education Board. We have Child and Family Services. There are various, on the urban context, there's a Taiwak Housing, there's a Business Development Corporation. Again, these could all be opportunities if you see where you have either strategic planning or policy stuff that you're doing that may touch on some of these areas, how you might reach out proactively with these organizations, say, we're here, we want to engage more and have a relationship, and speaking with them. So all of these have links that you can access to learn a bit more. And then I guess beyond that, somebody asked, what can planners do to better support reconciliation? I think a lot of it is, and this kind of goes back to concepts around treaty, it's relationship building and making those connections. And I think, you know, sometimes even the organizations are a bit overwhelmed in the work that they have, but if you're patient, and they may not get back to you directly, but if you try to proactively sort of develop some relationships, that can be very helpful. And I think the other piece is sort of seeing where the tea leaves are going, that we in the future probably will be in a place where the UN Declaration has much more impact on relationships, and you know, potentially seeing that as a guide to guiding reconciliation, because that is what the Truth and Reconciliation Commission itself recommended, not just for governments, but even for individuals and institutions as well. So really, that's all I have for my slides. One other thing, a bonus resource for you guys. Sometimes if you're places and you need to pronounce Mi'kmaq words and places, there's a link to a great pronunciation guide put together by the Confederacy of Mainland Mi'kmaq, and that can teach you how to say some words. And so that's it. Thank you for letting me go a little bit over. And Megan, I am more than happy to take questions if your colleagues who have been patient enough to stay on have any.
Wow. Okay. Thank you so much, Naomi. That was like, I took 3 pages of notes, so that was super helpful. I know, at least for the work that I'm doing right now. I did get a question in the chat about, so it says, many of us are land use planners. What are your thoughts on the intersection of land and Aboriginal law? In particular, could you share your thoughts on land acknowledgements made by governments or business?
Yeah, that one's a tricky one. There's lots of people who write about it. I think one of the biggest critiques about land acknowledgements is that it's sort of done in a sort of rote way that doesn't, like, you know, I mean, so the issue is that we're still on unceded territory. There are outstanding claims about, you know, the sharing of land and resources, and simply by acknowledging that you're on unceded territory doesn't solve that problem. So I think that's one of the critiques, is that sometimes perhaps people may think that they've done their reconciliation duties by simply doing a land acknowledgement. Now, at the same time, I'm not opposed to them, but it should be a reflective, as opposed to a, oh, I have to say this because this is what we do now. I don't know why I do it, and I don't know what it means. But when I've had colleagues like my dean or others ask, well, how should I do this? I said, well, make it meaningful. Talk about what it is you take it to mean, and your responsibility as being in Mi'kmaq territory, as being a signatory, you know, as being someone who benefits from the treaties and who benefits from living in Canada, and how you see your relationship with Indigenous people. That's what I tell people. So just, you know, I don't think it's wrong to do a land acknowledgement. I think it's not great if you're doing it just because you feel you have to, but you don't understand what it is you're doing. But if you impart it with how you see your role as you know, as an individual, or perhaps your institution, and your responsibilities in terms of treaty partners and reconciliation, I think that makes it stronger and more meaningful.
Mm-hmm. Yeah, that's a great advice. I know people are trickling away. I do have one question, and then we can wrap it up. I don't know if no one else put questions in the chat, so I'm sure everyone's just absorbing everything they've learned. One thing from my experience that I guess I have been unsure about is the formality of like building relationships with you know, all these organizations that you're talking about and the different levels of government. And like, I know a project I was working on, it had to be the mayor speaking directly to band council or chiefs, and like, because it's sort of like a government to government communications. So would it be, do you think it would be appropriate for like someone like me, who's just like a staff person, or my peers, to directly just start trying to build relationships with, like you talked about, Twyla, Gaudette at KMKNO, and that sort of thing? Like, are there more appropriate ways to build kind of more informal relationships, so that when the time comes when you have to more formally consult, is that appropriate, I guess? Yeah, so you're absolutely right. So I think that the question, like, if you were to reach out directly to a chief, like, don't expect that you're going to hear back, right? But you know, I mean, all of these, like, so band councils also have like various, you know, staff that work there, not just the chief and counselor. So most have a chief executive officer or band administrator. And so just like, you know, I wouldn't reach out to the premier directly if I had a question. Right. I would probably reach out to somebody who works in their offices, right? So it's the same sort of model. So Twyla would be the right person if it is a question that you want to engage with Nova Scotia or First Nations on, to start with her, because that's her role. Her staff role is to be the director of consultations. Now, she might not necessarily get back immediately. There's a lot going on, but you could send your request to her. KMKNO also has a communications officer who, just a sec, gotta let a little dog out. Communications officer who can field stuff. And so each of the band councils as well. And I think in my slides, I can send you, I have another chart that has the websites of all the First Nations, but if you needed to directly reach out to one of the First Nations, you know, the place you would start would be with the band administrator. So not
directly reaching out to the, the executive, the chief or council, or even potentially executive directors. But all of these organizations have websites. They all have people that you can contact, right? So that's what I would say.
Okay, yeah, no, that's a great way to think about it. Yeah. Okay, I have a question here. What is the Mi'kmaq sustainability principle? And I'm not.
Great. So I'm still sharing my, it's called Nedugalimk, Netukulimk, and there's a wonderful little video about what it means from the Unama'ki Natural Resource Center. So I'm just going to give you a link to it in the chat. I think I'm still sharing. I don't need to be. Hold on.
Yeah, you are.
Sorry. But there it is. Oh, well, you see the spelling and the whole thing, and I'll give you the link in the chat as well. Here you go. Yeah, and so you can learn more about that. Some great discussion by Elder Albert Marshall and other videos that speak about the concept of Nedugalimk. And Mi'kmaq are trying to use this a lot more now too. I mean, even informing, you may have heard about, some of the stuff around moderate livelihood fishing, but some of the communities are developing plans about fishing, but they're trying to incorporate this concept of Nedugalimk in it so that people are not overfishing and only taking, as much as they need to help themselves and their families.
Right. Interesting. I didn't know about that. All right.
Yeah.
Well, that is all the questions. I don't know if anyone wants to unmute right now. Now is the time. But if not, oh, I see. Thank you for a very informative presentation. Yeah. So yeah, if anyone has questions, or I can kind of be the connector of emails. So Naomi, if you want to send anything to my colleagues and peers, then definitely do that and I can spread it out, and same vice versa. If anyone needs to connect with Naomi, maybe just go through me, and I'll put my email in the chat.
That's what you get for organizing this, Megan, you know that, right? But also my email's at the back of that presentation as well.
Great, yeah. That was super helpful. Thank you so much.
Very welcome.
I learned a ton, and yeah, it goes to show, like, you think you know something and we have so much more to learn all the time. So yeah, we could probably still do probably 20 more sessions on this topic and still not even scratch the surface, really.
Yeah, maybe not like immediately, but at some future, maybe in the next 6 months or so.
Yeah. All right, well, thank you so much. I think no one else has any further questions. They're getting lots of thank yous and that this was helpful, so that's great. So yeah, thank you so much, Naomi, and we'll talk soon. And thanks for everyone for staying on.
All right.
Okay,
See you later, guys. Take care. Bye.